Subcommittee 3154 bill subcommittee to order. This is a bill having to do with joint physical custody. I think I'm going to summarize the bill here. Currently, joint physical care is an available form of custody arrangement in dissolution. This means both parents have legal custody, the default in all Iowa dissolutions, and both parents are awarded equal time with physical custody, as opposed to one parent having most of the time and the other receiving visitation. This form of custody is currently voluntary. The bill would make it the default version and require a court to provide evidence why it should not be any time another form of custody is chosen. A rebuttable presumption. Child abuse or neglect are sufficient to rebut. This system of dissolution frequently requires the parents to be geographically close to each other, and also requires that whichever parent makes the most money pay the other parent child support, which can fluctuate throughout the duration of the arrangement, thus tying the parents to each other financially until the children are age majority. That's just a little short summary of the bill. I want to thank you all for coming. It's nice that you took the time and effort to come here, and I'm opening the floor up. I'll ask if either of the other committee members have comments, and if not at this point, we will open the floor up, and go ahead, ma'am.
Thank you. Good morning. My name is Jocelyn Fry. I am a candidate for Iowa House of Representatives. I am the newly elected chairwoman of the Libertarian Party of Polk County, and I'm here today as an associate of Families United Action Network to support a bill that is very personal and close to my heart. I want to start by thanking Senators Garrett, Senators Elder, and Senators Bisignano for meeting with us. I also want to thank the members of the various organizations here today, including Parental Guardians of Iowa, Americans for Equal Shared Parenting, and Leading Women for Shared Parenting, just to name a few of the wonderful groups that Fawn has developed relationships with. I'd also like to thank the Iowa Bar Association for joining us, and all others, both in favor and in opposition to SSB 3164. The health and happiness of Iowa's children are most important to us all, despite strong feelings and differing experiences. Those speaking in favor today have diverse backgrounds. Some, such as myself, represent the intentions of Families United Action Network. Some represent other organizations, and some represent no organization at all, only themselves as individuals. Issues of family law are intensely and emotionally charged, so we ask that anyone speaking today should only do so if they are committed to respecting others and working together for the betterment of Iowa's children. My husband and I were both previously married and have children both apart and together. I regularly ache for my stepsons as they hold their sobbing younger siblings, saying goodbye before another long absence. 4 days per month isn't nearly enough time to share hobbies, to get to know their friends, and to impart important values. What good reason could there be for 2 empty seats at the dinner table most nights? Their mother simply didn't want to share parenting. I also offer another perspective, and that of a mother who does share parenting. My 2 teenage daughters have had the joy of living equally as possible with both their father and myself for the entirety of the 10 years that we've been divorced. Their well-adjustment in having grown up with both of their parents involved in their daily lives is obvious. Their father and I have each had the opportunity to build meaningful relationships with our girls, offer emotional stability, and maintain trust. It does require the maturity and cooperation of both parents, which is certainly in the best interest of all children. Shared parenting works, and my daughters wouldn't have it any other way. Don't let another generation of kids grow up with holes in their hearts, missing half of their families. Don't let another generation of kids become prizes to be won in a war where they can only lose. I urge our legislators to move forward and ultimately pass a rebuttable presumption of shared parenting bill so that the next generation of Iowa's children who must endure a divorce or separation can maintain strong familiar bonds that will benefit them for a lifetime. Thank you.
Thank you very much. Go ahead.
So my name is Travis Grassel. I lobby for Families United Action Network. I'm a father of 2 boys, and my girlfriend has 3 children that she hasn't seen for a long time due to some of the issues we're talking about today. So the issue is very personal, but it's bigger than any individual in the room. It comes down to the statistics and the data that supports why children need both parents. And what we believe is that this bill will help establish consistency for children and give them an opportunity to have equal time with both parents, which is in their best interest. And we want to help eliminate some of the fighting that goes on with the current system in place. And we think by having a rebuttable presumption, it still allows the courts to maintain control when they need it, but it keeps the parents from fighting so much, and that's where the children are really suffering. And if you have the children benefiting from the involvement of both of their parents equally, you will have a society that's much more productive and adults when they grow older that will give us a better result in the long run. So I appreciate your time and thank you very much, Senators, for listening to this issue.
Thank you. Who's next?
I'm Jenny Norman with the Iowa Bar Association, and we are currently registered in quote opposition to this bill. We have a handout that we prepared. We brought one of our members of the family law and juvenile law section to discuss this a bit further.
My name is Stacy Warren. I apologize for my voice. I'm a former chair of the Iowa State Bar Association Family and Juvenile Law section. We are opposed to this bill. I'm speaking as a family law practitioner practicing exclusively in the area of family law for over 22 years. The issues presented and what this bill does in terms of it is asking to create a presumption for joint physical care. And in doing so, that presumption actually substitutes for actual factual evidence in a case. Absolutely no two families are alike. Your family in all of its, what you have described, not one family is like any other family. No child should be buttonholed in terms of being treated like every other child. The facts and circumstances of each particular case are considered by our courts, and they need to be considered by our courts in doing what is in the best interest of the children. Social science does not support the presumption that joint physical care and equal time is in the best interest of the children. And as a family law practitioner who deals with this, and I've also had shared physical care relationship with my two stepchildren who are now 27 and 23. It takes an extraordinary amount of communication at a much higher level than when the parties are actually in the same household together. The level of communication required in a shared physical care arrangement is tenfold of what is required when the parties are together. Oftentimes, people will agree to a joint physical care arrangement at a dissolution because they want to give it either they want to give it a try or there's pressure points. One party doesn't have the ability to argue against it. But oftentimes, we find those parties coming back in a modification action within 5 years or less. And at that point in time, the court is considering all of the conflict that has gone on and the harm that, frankly, children are the ones who suffer the most. So when you come back, you are delaying the fight or the argument or the dispute that the court could have heard at the time of the dissolution. Right now, our courts are free to consider the request. If one party requests joint physical care, they go through the analysis. And let me just say, our judges are committed to receiving facts and evidence. And in addition, we have changed the law recently related to adding a component for child and family reporters, which is an additional method of getting evidence before the courts as to what is in the child's best interest. It's factual evidence relating to each individual case which should be considered. There is no family that is exactly like another family. What you have here with the joint physical care presumption is all of the facts don't matter. That's just the point that you're starting from. Joint legal custody is not the same as joint physical custody. We do have a presumption for joint legal custody in Iowa, and that stems from the constitutional rights of parents. But the issue should not carry over to joint physical care. Studies show children are harmed when parents are in conflict. There is a significant amount of conflict in shared physical care relationships that they find themselves back in court. Children are harmed when both parents agree and they operate from the same perspective. You're also assuming that they're on the same power and control levels, and that's not necessarily the case. It is harmful to children to remove the standard of best interests and prevent the court from considering that. The Iowa State Bar Association stands in opposition to this, and we would ask that our comments be voted.
Could I ask you a couple questions?
You may.
Do you have any statistics on how often you have joint physical care as compared to how often you don't, as far as when divorces take place?
Well, in terms of the higher number of cases are not getting resolved because when people do not agree on joint physical care, those cases are going to litigation at that point in time. And so, and I'll speak for Polk County just because I've had a number of discussions with our family law court judges. Like, the highest number of cases in our system right now are family law cases. The vast majority of them are based on custodial disputes. And so if you don't have that agreement, one parent is saying, I do want joint physical care, and the other parent is saying, I do not. And these are the reasons that we do not. You are automatically forcing that case into the litigation stand with a presumption of joint physical care. Parties are still going to be, if they are not in agreement, they're going to oppose it. And you're doing nothing to decrease the level of litigation. I do not have exact percentages.
I can look into it.
And we can pull that information. It is rapidly changing, I agree. But the fact is that there is a high number of cases where we are arguing either for or against joint physical care, and we are laying out all of the facts for the court to consider the best interest.
Okay, thank you.
Thank you.
Okay, go
If
ahead.
I may,
I saw you first.
so I want to thank the bar for their comments. I do respectfully disagree. So I do agree with the fact that we don't want all the kids treated the same. Unfortunately, that's what the current law does now, because in over 80% of cases, one parent will receive primary custody while the other is going to receive every other weekend, maybe 2 weeks in the summer, and a Wednesday visit during the week. So we're buttonholing, we're shoehorning them into this arrangement. We're treating them all the same. And to the point that facts aren't considered, I believe that would be the case right now. We have what's called a preponderance of evidence standard right now, wherein mere words and allegations hold weight in court. And I actually had hearings in my case just yesterday where this is in fact the case. Raising it to a clear and convincing standard is going to cut that fluff away, and we're now going to listen to actual and factual evidence as opposed to just accusations. So the notion that we're dismissing facts by introducing a rebuttable presumption just doesn't hold any water in my mind.
Okay, somebody, go ahead.
Yes, sir. My name is Tom McDermott. I'm with Families United Action Network as well. And, you asked the question if we had any statistics on the results for the child custody. And in 2011, Iowa Fathers group did a study on contested child custody results. And a lot of times the results get watered down because uncontested results are often thrown in the mix, so you don't get an accurate picture of how many children, are in split families versus not. And anyways, in the contested child custody results, only 19% got joint physical care, with mom getting 73% and dad getting 8%. And that's just, and that was done in 3 different counties in Iowa, and that's the results that they came up with. As far as studies, there's been numerous studies. Dr. Linda Nielsen cited 40 different studies in her paper, and she stated that joint physical care parents generally did not have better co-parenting relationships than single physical care situations. So the benefit cannot be attributed to better parenting or lower conflict, better co-parenting or lower conflict, which is often cited as reasons for not having joint physical care, because the parents can't get along. So even when in situations where they didn't get along, they still, the children actually did better in those situations.
Okay, I think this gentleman is next, I believe. I'm gonna try to get to everybody. We have until noon, so, we've got a fair amount of time, and I wanna give everybody a chance that wants to speak, so go ahead.
Thank you, Senator. My name is Chad Castell. I'm a disabled Army veteran, father of 4 beautiful daughters. My wife and I have 3 together, and I have 1 from a previous marriage. I'm also a victim of the current judicial system. When I grew up, I lost one of my parents in this system, and it was detrimental to my siblings and I. Most of my siblings are not what most people consider successful. My brother and myself, I would like to think most people would consider successful out of that situation. Unfortunately, I've got siblings who, all of them are divorced. This system is geared toward leading children and mirroring what their parents do, and it is extremely unfortunate. When I was in the Army, I got divorced. My ex-wife brought my daughter to Iowa, where she was from. I had no contest to that. When I got out of the Army after serving 11 years, 2 combat tours, as well as 3 other tours in other countries, I finally came home, and I made the choice to move to Iowa to be close to my children. So I filed a motion with the courts and requested that they introduce joint physical care after a grace period of 2 years of having a ramped up parenting plan and seeing my children. I felt that was fair. It would allow my children to reintegrate into the family, and we would go into joint physical care. Of course, my ex-wife contested that, and we went to court. I feel that the judge was extremely biased. As a matter of fact, the judge himself told me, I've been a stepfather and I know what you fathers do. The judge himself told us that. Less than a month later, about our hearing, not only did I have less time than when I was stationed in the Army, actual day counted, I also had no holidays. That was also taken from me. Unfortunately, after $20,000 of bills and trying to go and get an appeal of another $10,000, of course it was refuted. Under our current judicial system, there is no way for a father to have, or even a mother in the opposite point of view, to have an ability to go and have their children. I have a phenomenal career where I'm a general manager of a construction company. I have my master's degree from Grand Canyon University in business. I'm not a bad parent by any means. And here I stand.
Thank you. Let's go back over here. Go ahead.
Good morning. My name is Molly McPartland. I'm here as a representative from the Iowa State Bar Association.
I'm also an attorney that practices in the area of family law exclusively as an advocate for children whose parents are embroiled in high conflict divorce and custody cases. The position of the Iowa State Bar Association is in opposition to this change, but for precisely the reasons articulated by Ms. Warren earlier, and I'd like to follow up on some of the reasons in support of it. Primarily, this change takes away the court's ability to give a case individualized attention based on the best interests of the child. That best interest of the child hook is central to our family law practice. It's central to family law determinations. Those have to be an individualized determination. No two families are the same, and respectfully, I disagree that the families are treated the same right now. Iowa is rich with resources for children and families, and each case is given the individualized attention that it demands by the court. The way that takes form is in a period of judicial fact-finding, both in temporary matters and at the final determination of the case. So judges are tasked with that job to judge the facts of the case. That's the judge's role. Now, what this change does is not only create a presumption for joint physical care, which does not work for every family. It then makes it extremely difficult for a judge to overcome that presumption because they must establish clear and convincing evidence not only that joint physical custody is not in the best interest of the child, but that joint physical custody is unreasonable. Clear and convincing evidence is the second highest burden in the entirety of our legal system, behind only beyond a reasonable doubt. That's putting judges in a position where it is extremely difficult for them to make findings that would support a finding other than joint physical care. And that, the fact of the matter is, joint physical care does not work for every family. I think we've heard today stories of the desire for different periods of transition, the desire for different arrangements. Many families have work schedules that can't accommodate shared care. This doesn't allow families the flexibility that the current system does, and it does not allow judges the flexibility that the current system does. Finally, while there are many families who benefit from joint physical care, that is an option under the current system. Families can request that option, and then the judge is expected to consider that option, and in fact required to consider that option. That is not an insignificant mechanism to make that request, and we believe that we need to keep the focus on the best interests of the child. The best interests of the child in family law cases is individualized attention by the court.
Okay, okay, go ahead.
Yeah, my situation started 8 years ago. I had no idea that this was going on until my situation started. I ended up with 6 overnights a month with my son. That's a visitor, that's not a father. And I started getting calls from parents all over. I now have 470,000 followers on Facebook in the last 2 years from fathers contacting me, telling me they're in the same type of situation. And it's not just fathers, it's mothers too. And we talk about best interest of the child. How is it in the best interest of a child to start a case out carving out one parent out of that? It just seems common sense to me that we're truly looking out for the best interest of a child. What child doesn't want equal access to both of their own parents? If we asked every person in here, when you were growing up, would you rather have had your mom or your dad? Most people would say both. So if we're looking out for the kids, why shouldn't we start out, we just have the Super Bowl. What if we would have started out the Super Bowl, one team gets 82 points and the other team gets 18 points? No, we start the Super Bowl at 0-0 on equal footing. And we're talking about something a lot more important than a Super Bowl. We're talking about kids' lives. Tonight, 24 million kids will go to bed without their biological father in the house. Yes, I agree some of those fathers walked out. But you can't convince anybody in this room that 24 million fathers walked out on their kids. I'll tell you what happened. A third of them walked out. A third of them are aggressively seeking custody. And a third of them realized, my back's stacked against me. Because we walk into an attorney's office. When I started out, the first 3 attorneys I talked to wanted me to shoot for full custody, even though I asked, hey, why don't we just go for 50-50? Why? Because if you keep that adversarial relationship going, they can rack up billable hours. What if instead of putting the money to the attorney fees, we could say, you know what, it's in the best interest of our kids, let's agree on 50-50 and put that money in a college fund. That yes, there are other situations. But this still allows for that, judges still have discretion, we're just saying, instead of automatically giving one parent the primary custody, why don't we just start until we know any facts, let that kid have equal access, and now let the judge decide if we need to move the ball one direction or another. Thanks so much.
Thank you. We have somebody else? Okay. Oh,
It's fine, he can go, and then I'll go next.
all right.
Jeff Jansen, I'm an attorney here in town. I practice in the area of family law. I disagree with the position of the bar. Although they are against this bill, I am completely in favor of it. And I say that even though this bill is against my personal interest as a practicing attorney. Practicing in the area of family law, when I rack up these billable hours, that's when I get paid. If we have this rebuttable presumption, conflict will go down, my billable hours will go down, our court cases that we see going to trial will go down, and I will lose out money. Saying that, I'm still in favor for this bill, because this bill sets the stage so it's equal for everybody. This bill sets the stage so a child, which is in their best interest to have access to both parents, can have that access. Yes, there are situations where this may not work, where shared parenting is not in the best interest. But this bill allows for the case to go to trial, for the judge to hear the evidence, and for the judge then to make that determination. Right now, as it currently stands, although there is an ability for shared parenting, you rarely ever see that in any case. When you go into mediation, it's mom's gonna get primary. That's just typically how it is in 90% of the cases. We do have access to great resources, to great things. One of those is mediation. We do have great attorneys who work hard for their clients and who work out settlement agreements. Those are still options. If 50-50 shared care is not going to work, attorneys can work for those settlements. Mediation is required.